question that there's jurisdiction, and then due process requires notice and opportunity to be heard and to defend. And so if they're going to insist with a death warrant that they have jurisdiction, the prosecution has to have presented something. Because if they have the evidence of jurisdiction, they're supposed to give it, because what they're doing is they don't have it, they're lying, or the worst, the best that they could be doing is covering for the prosecutor. Well, we have a stack of evidence against you, sir, but I don't have to disclose that to you before you enter a plea. It's complete nonsense. If there's jurisdiction to force a plea, there must be evidence proven as jurisdiction and as subject to challenge. And just because these lawyers wear black robes and call themselves honorable, remember, if someone has to call themselves honorable, chances are they're not. And that's they gave themselves immunity, and they gave themselves these titles. So, and the fact that they can lie with immunity is not lost on them. They take advantage of it all the time. So let's go through and prove that this is a lie. All we have to do is look what happens. If you or I file against them, what do? They file immediately a motion to dismiss for a lack of what? Oh, that's right, jurisdiction. They challenge jurisdiction at the get-go. The first thing they do, they're not arguing the jurisdiction's a trial issue, and I guarantee you the hack judge who they filed a motion with is not going to tell them, Mr. U.S. Attorney, you should know by now that jurisdiction's a trial issue. The NSA is going to trial. No, it does not work that way, because jurisdiction's not a trial issue. Can be discussed there, but it's not exclusively a trial issue. It's absolutely, it's insane on its face. It's ridiculous. So what we do is, I know I use this all the time. It's ACLU versus NSA. I'll have it linked up on the website. It's a 65-page PDF. And what happened was the ACLU back in 2006, because we already knew what Snowden was revealing. I guess the main things they're attacking Snowden on. We already knew that they were doing this. So the ACLU brought a lawsuit on behalf of some people and newspapers for the warrantless wiretapping, that they were gathering all this data without a warrant, and the NSA filed a motion to dismiss for a lack of jurisdiction and move for summary judgment. Now, this is directly from the Court of Appeals, saying this appeal presents a number of serious issues, none of which can be addressed until a determination is made that these plaintiffs have standing to litigate them, stating that there is no doctrine of hypothetical jurisdiction. See, standing at the federal level is an issue of jurisdiction. If you don't have standing, the court has no jurisdiction. This is on appeal. There was no trial. So someone please tell me why in the world these judges keep lying, saying that jurisdiction is a trial issue, when you file against them, they file a motion to dismiss claiming you don't have that the court has no jurisdiction over them, and they never go to trial. Could you imagine if that was true, that if you file against one of these IRS agents, you file against the governor or the president or any one of these psychopaths, and they actually had to go to trial? That'd actually be a good thing. But it's not going to happen, because there's double standard here. There are standards that apply to us, there are standards that apply to them. And this thing about jurisdiction being a trial issue is one of those double standards. So all we have to do is go through this NSA, ACLU versus NSA, and plus there are thousands and thousands of other cases there. If you dispute this, file against the IRS, an agent, and see how quickly they get it dismissed for lack of evidence proving jurisdiction, for sovereign immunity, and this other crap. They never have to go to trial, because jurisdiction is not a trial issue. It's an absolute lie. So when some black robe attorney snaps at you that jurisdiction is a trial issue, you object and you snap back, objection, that's not true, and you know it. If I filed a complaint against you, then you'd file a motion to dismiss for lack of jurisdiction. And you certainly wouldn't have to wait till trial. Your little buddy, your black robe friend there, would grant the motion and never force you to go to trial. It's absolutely unheard of. So, so that I think settles that. If anyone disagrees, 218-632-9399. So another thing too, like I think I mentioned already, is that so cops and other low-level bureaucrats are making legal determinations every day that there's jurisdiction over us. They are insisting the Constitution and codes apply because we're physically in Arizona. Again, that's an argument. It's not a statement of fact, and it is subject to challenge. So the claim that jurisdiction is a trial issue, I think reasonable people like us can see that there's absolutely no merit to it. Absolutely no merit. So the next big lie we'll get to is that jurisdiction is an issue of law, not an issue of fact. But we'll address that in the next segment. My name is Marc Stevens. You're listening to the No State Project here on LRN.FM, the Liberty Radio Network. Yes, welcome back to the No State Project. I'm your host, Marc Stevens, author of Adventures in Legal Land. This is the live edition of the No State Project. Glad to be back with you live from the fortified compound in Phoenix, Arizona. You want to join us? It's 218 my gosh, I'm drawing a 218-632-9399, 218-632-9399. We'll get to calls in just a few moments. I want to finish up here. We're talking about the second of many lies. This is one of the more common ones. This is the second one that you'll hear from a judge. He'll snap at you. And critics, they'll get up on their legal high horse and say, "Oh, Marc, you don't understand. You're so stupid. You don't understand that jurisdiction, my boys. Jurisdiction's an issue of law. It's not an issue of fact. I mean, that's ridiculous over here." Anyway, well, that is not true if somebody is arguing or claiming that the Constitution and laws apply to you because you're physically in Arizona. That is an argument or a claim, an accusation, if you will, and like any other claim or argument, if it needs to be based on fact. When they get all highbrow on you and they say, "Oh, silly peasant, jurisdiction's an issue of law, not of fact," what they're actually saying is, it's lawyer speak for we can't support the argument. I got nothing. So I'll just say the law applies as a matter of law. The law applies as a matter of law, 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 as a matter... You get the point. It's turtles all the way down. But this is the garbage that you'll get from these people because all they have is a willingness to kill you. Their jurisdiction really is nothing more than a willingness to have you killed to get your compliance. And those who say, "I'm crying BS here, Marc," it's called the force continuum. Look it up. It's absolutely true. And cops do not like when you bring that up. Okay, so what this argument that of jurisdiction that the Constitution laws apply, it's based on the false argument that if you're physically in Arizona or Toronto or wherever, then the Constitution laws apply. Now, I have plenty of objective records on markstevens.net to show that these politicians and bureaucrats can't produce one single fact connecting me and my physical location with their laws. That's why they have to say, "Well, it's an unprovable argument, Marc. It's it's unprovable. You don't have to." Or they'll say it's a philosophical attack when I'm just asking a question. But this is not a philosophical issue. I've done a tremendous amount of investigatory work on 3 continents, well, right here from the fortified compound, of course, to confirm this. We got it confirmed on 3 continents. So when a cop argues the court has jurisdiction, he's arguing the Constitution and laws apply to me because what? I'm physically in Arizona, and that therefore gives him and the court jurisdiction over me. This is just an argument. As with any argument, it must be supported by facts and logic. Otherwise, you have an unprovable, subjective claim. There's a very fancy Latin phrase for this. It's I'm going to butcher this, so please, I don't want the Latin scholars jumping all over me for this. Vox et praeterea nihil, which means voice and nothing more. So when you say jurisdiction's an issue of law and it's not an issue of fact, what you're saying is, it's my voice. Yeah, that's it. Nothing but the wind. Or the more common, it's true because I said so, which is basically what John Buttrick did last February. You can get that HD video at markstevens.net. So they're saying my argument is right because I said so, and some other lawyers said so. That's why I mentioned in Government Indicted, it's kind of the Saul Goodman defense, the defense or support for your argument. I know a guy who knows a guy who knows another guy. And that's really what precedent is. Well, the courts have ruled because I'm a lawyer and I said it, and then I went to another lawyer with a black robe and he said it, and then that black robe lawyer, he quoted another black robe lawyer and he said it, and then they told 2 friends, and then they told 2 friends, and then they told 2 friends. Hey. So that's really what it comes down to. The judges spew this garbage just to cover up the fact that the prosecution's argument has no support. There are no facts, there are no logic. So don't buy into the double standard fallacy either, that an argument there is jurisdiction is somehow different than any other argument. It's not. And you can look at the NSA case that I have at markstevens.net on the article to prove that. So those are the two main lies I wanted to go through. So when you do hear these lies from these lawyers, you need to object, and you need to call them on it. Jurisdiction, once asserted against you, is just an argument and is subject to challenge and not only an issue for trial. As with any argument, it must be proven with facts and logic. Kind of give you an example of what this is like when it actually plays out. So someone will say to me, well, the Constitution and laws apply to you, Mark, because you're physically in Arizona. Oh, okay. Well, why is that argument true? I mean, what facts is it based on? Well, no facts or logic. It's not provable objectively, but you got to take our word for it. It's true because we said so and these other lawyers did. So it's just because you said so. Well, other lawyers said so also. Yeah, that's a really strong argument. Imagine me trying to get away with that. Well, you don't have jurisdiction because you don't have jurisdiction. Now, it's not just me saying that. I know some other lawyers that said that. That's absolute nonsense. They're not going to accept it from you because it's garbage, but they expect us to accept it. But it's just as much garbage. Then you should be objecting to that. If you go to court, you're going to hear one of these two lies or both. So you need to call them on it. You need to object because all the judge is doing is covering for the prosecutor. That's all he's doing. So again, these are two common judicial lies. Yes, judges lie all the time. If their lips are moving, if they're communicating with you in any way, they're lying. And that's the name of the article. It'll be available at markstevens.net.